not to think about the abuse she was subjected to. The moment I allow myself to think about it, I feel I could collapse, she said. Amir al-Qashami and Fatin Nasser, who were recently released and granted alternative sentences, were convicted in a mass trial of 60 individuals, the same mass trials as torture victims Ali al-Arab and Ahmed al-Malali, who were executed in July 2019. Zainab Marhoun, who's out of prison now, her detention had a detrimental impact on her children, who now fear her leaving the house alone in case she might be taken again. Zakia al-Barbouri, when she was arrested, she was subjected to enforced disappearance, and she said she's now psychologically unstable and constantly concerned that authorities will investigate her again. Zahra Sheikh fled Bahrain 6 weeks after her interrogation in search of asylum in the UK. Since her ordeal, she has been prescribed medication for anxiety and depression. And finally, Najah Youssef and Ibtisam al-Saigh, who were physically and sexually assaulted by the National Security Agency, and I think out of all the 9, they were subjected to the most horrendous abuse. When I met Ibtisam not long ago, she told me, "I can no longer sleep in the dark without a light on. When I turn off the light, I remember the room where I was tortured." Before being released, Najah told us, "Sometimes I speak normally about my ordeal, but the truth is that I'm bleeding from within. It's painful, and I have no idea when all of this is going to end." I think the importance of these statements is that they show us how the increased targeting of women activists is not just planned with the ultimate objective to scare and silence these women, but to do the same with their families and potentially the entire communities. If you speak out, this is what is going to happen to you, basically. Probably the Bahraini government did not expect these women to come forward and break their silence, but they have, giving us the chance to write this report. Writing the report was definitely not an easy task. In an ideal world, we would have liked to visit Bahrain and to see these women and to interview them in person. But since 2015, the Bahraini government has refused entry to human rights organizations, and special rapporteurs of the UN are also banned from entering the country. So going to Bahrain was never really a feasible option for us. However, we were still able to draw incredible detail from the women by establishing alternative channels of communication. Since the beginning of 2017, we have been in regular contact with the women, their families, and lawyers through phone calls, sometimes several times a week. Their testimonies revealed explicit misconduct at every stage of criminal procedure, with a diverse range of due process violations perpetrated by law enforcement, judicial, and prison officials. Access to official documentation was also challenging. We were able to obtain court rulings, public prosecution documents, and medical reports for 5 of the women. But in some cases, the Bahraini government refused to release official documentations, and even the lawyers themselves didn't have access to those documents. And in other cases, they refused to reveal it to us for fear of retribution. In the absence of key documentation, we sought the opinion of our esteemed colleagues from Global Rights Compliance. Oliver is here with us today, Human Rights Watch, Amnesty International, OMCT, and the Universities of Toronto and East London, who have experience on issue of women in detention, torture, trauma, and unfair trials. And speaking with them was enlightening, as they were able to corroborate what the Bahraini government had denied. As part of our work, we have submitted also several complaints on behalf of the women to Bahraini oversight bodies such as the Ministry of Interior Ombudsman and the National Institute for Human Rights, addressing concerns ranging from ill treatment, treatment in prison, and during interrogation. We have also scrutinized the military, technical, and political support the UK and US provide to Bahrain to assess the impact this support has on the human rights in the country and also on these individual cases specifically. The responses we obtained demonstrated that Bahrain has in place a highly efficient system that whitewashes and conceals human rights abuses, and that allied Western governments are facilitating the propagation of these abuses and of impunity. Without effective and independent oversight institutions promoting accountability for human rights violations, political prisoners such as these women are at risk, with little means for redress. As part of our recommendations to the Bahraini government, we demand a timely, transparent, and thorough investigations into allegations of arbitrary arrest, coercive interrogations, physical and sexual assault against the women of this report, ensuring that those responsible for these abuses are held to account. We demand the release of Hajar Mansour, Medina Ali, and Zakia al-Barbouri, and the provision of reparation for all the women whose human rights have been abused. Finally, we urge the government of Bahrain to allow country access to special rapporteurs on torture and violence against women and to the working group on arbitrary detention. These 9 women have all come forward and shared their stories at great personal risk. We now need to act. The recent release of Najah Youssef last month and of Ibtisam As-Saer in October 2017 showed us that our voices can actually be very powerful. These women have broken their silence, but now it's on us to do everything we can to make sure that their efforts do not lie in vain. Thank you.
Thanks so much for that, Lucy, and thanks for illuminating the voices of these women in detention. They're horrible stories to listen to, and something that really jumped out for me as you were talking is, as you said, the impact that arbitrary detention draws more silencing, repression, and especially in the case of Hajar, when the reprisals come into play, that's compounded by that.
Yeah.
And so now, if we look specifically at the case of Hajar, who, as you say, is serving a 3-year sentence?
Yeah,
right?
She is.
So Reprieve co-authored a complaint to the working group on arbitrary detention that resulted on its opinion as her case as one amounting to arbitrary detention and relating to reprisals. So Amar, as hers is one of the emblematic cases in this report that emerged, can you please explain to us a little more about it and how you understand its significance to be, first within the context of the working group on arbitrary detention and more broadly if possible?
Absolutely.
Thanks so much.
As I've just been introduced, I'm Omar Suleiman. I'm one of the Middle East and North Africa caseworkers at Reprieve. I'd like to take this opportunity to thank Al Salam Foundation and ADHRB for inviting me here today. This morning I'm going to speak on the opinion of the United Nations Working Group on Arbitrary Detention in the case of Ms. Hajar Mansour Hassan, and that's an opinion for which Reprieve helped to coordinate the complaint. Just a couple of words on Reprieve. Reprieve is an international legal action charity which was founded in 1999 by human rights lawyer Clive Stafford Smith. We provide support to some of the world's most vulnerable people, including people sentenced to death and those victimised by states' abusive counterterrorism policies. Based in London, but with offices and partners throughout the world, Reprieve is currently working on behalf of 77 people facing the death penalty in 16 countries, including Bahrain. Reprieve's vision is a world free of execution, torture and detention without due process. Now, in Bahrain, Reprieve's work is focused on those facing the death penalty. We currently assist 3 death row prisoners, Meher Abbas al-Khabbas, Hussein Musa and Mohammed Ramadan. All 3 men suffered appalling torture at the hands of Bahraini institutions, leading to confessions to death penalty offences. Now, on our work in Bahrain, Reprieve works in close conjunction with our partner organisations, the Bahrain Institute for Rights and Democracy, BIRD, and Americans for Democracy and Human Rights in Bahrain, ADHRB. But in 2017, there were reprisals against 3 members of the family of Sayyid al-Wada'i, the director of BIRD, and our very close partner. We believe that these reprisals were a result of Sayyid's work as a human rights activist, particularly concerning his activism on death penalty cases in Bahrain. It is for this reason that we became engaged on this case. Sayyid al-Wada'i, who has sought and been granted asylum in the UK, is an internationally respected human rights defender and a vital partner in the work against the death penalty and breaches of human rights related to the death penalty in Bahrain. As acknowledged in the European Union Guidelines on Human Rights Defenders like Sayyid are increasingly coming under attack, and it is vital to the protection of all human rights that the rights of human rights defenders are upheld. By way of background, the family of Mr. al-Wada'i have been subjected to numerous human rights violations by the Bahraini authorities in response to Bird's work, including arbitrary detention, unfair trial, ill treatment, and possible torture. In April 2018, Reprieve submitted a complaint to the UN Working Group on Arbitrary Detention, WGAD, that concerned the persecution of 3 Bahraini citizens, all of whom were members of the family of Sayyid. They were his brother-in-law, Sayyid Nasser al-Wada'i, who was 19 years old at the time of the complaint, his wife's cousin, Mahmoud Mansour, 30 years old, and his mother-in-law, Hajar Mansour Hassan, 49 years old at the time. Given that we're here today to discuss female political prisoners in Bahrain, I will focus specifically on Hajar. Hajar, along with her son, Sayyid, and nephew, Mahmoud, was detained and tortured by Bahraini government officials. They were coerced into confessing to involvement in a purported terrorist activity, which included the planting of fake bombs in January 2017. All three have subsequently been tried and convicted in trials that relied on those confessions, and they remain in custody. As the working group complaint alleged, they were persecuted as a form of reprisal against Sayyid for his ongoing advocacy in support of democracy and human rights, which has generally been critical of the Bahraini government. Their detention is therefore arbitrary and stands in ongoing breach of international law. With regards to the arrest itself, on the 5th of March 2017, Hajar Mansour Hassan was summoned to attend the office of the Criminal Investigations Directorate, the CID, for interrogation within 2 hours. At the office, while waiting to be interrogated, Hajar received a phone call from her son, Sayyid Nazar al-Wada'i. He explained that he had been tortured by CID officials and described his initial interrogation. Hajar immediately called a family member to inform them that she had received a call from her son. This was the last time that Hajar spoke to her family before she too was arrested. Hajar was interrogated without a lawyer present and without being informed of the charges against her. She was held in detention for 3 days without charge. She was then interrogated from 4:15 p.m. to 2:30 in the morning on the 5th of March 2017. Throughout this period, she was required to remain standing. This resulted in her collapsing and fainting and sustaining an injury to her hand and shoulder. She was transferred by ambulance to a hospital where she was given intravenous fluids. On the 6th of March 2017, Hajar was transferred to Isa Town Women's Detention Centre. On the same day, her family attempted to visit her, but were denied access to her. On the 7th of March 2017, she was transferred back to the CID. Hajar was questioned about Sayyid al-Wada'i, as were Sayyid Nazar and Mahmoud Mansour. All three family members were coerced during their interrogations into confessing their involvement in the fake bomb plot previously mentioned. The interrogations of Sayyid's family members coincided with his attendance at the 34th session of the UN Human Rights Council held here in Geneva from the 27th of February to the 24th of March 2017. Now, on the 8th of March 2017, Hajar, Sayyid Nazar and Mahmoud were taken to the office of the public prosecution. They were presented with terror-related charges concerning 2 separate incidents that allegedly took place on the 20th and the 28th of January 2017. During the interrogation at the public prosecution, a lawyer accompanied only Hajar. The public prosecution accused Hajar, along with Sayyid Nazar and Mahmoud, of planting fake explosives on the 28th of January 2017 at approximately 6:30 p.m. at the Mayouf roundabout in the village of Ali. Hajar again denied this accusation on record. The evidence presented by the public prosecution on this charge was also limited to confidential sources, the coerced confessions of the three, and the fake explosive which authorities claimed to have found at the location. Hajar denied the accusation and was asked by the public prosecution, "Why did you confess at the CID?" The public prosecutor noted down Hajar's response, that her confession was a response to the threats and coercion of CID officials made against her, her son and her nephew. Hajar also told the prosecutor, "If you are sending me back to the CID, I will say whatever you want me to say and I will sign it." On the 7th of May 2017, the victims were tried on the above-mentioned charges. All were refused bail, and on the 30th of October, the victims were each sentenced to 3 years, and all 3 victims remain in custody. On the 20th of December 2017, Bahrain's Court of Appeal upheld the sentences of all 3 individuals. Now, as I mentioned earlier, in April 2018, Reprieve submitted a complaint to WGAD on behalf of Hajar and Sayed Nasser and Mahmoud. In the WGAD decision adopted on the 19th of January 2019, the working group concluded that Mr. al-Wada'i's family were deprived of their liberty, interrogated and prosecuted for their family ties with Sayyid al-Wada'i, and that these were acts of reprisal. Furthermore, the working group opined that the deprivation of liberty of Hajar, Sayyid Nasser and Mahmoud being in contravention of Articles 2, 3, 5, 9, 10 and 25 of the Universal Declaration of Human Rights, and of Articles 2, 7, 9, 10, 14 and 26 of the International Covenant on the Civil and Political Rights, the ICCPR, is arbitrary and falls within categories 1, which is deprivation of liberty without invoking any legal basis, category 2, as victims' detention amounts to a reprisal against a human rights defender, Sayyid al-Wada'i, and category 5, constituting illegal discrimination under international law. Now, the working group requested that the government of Bahrain take the steps necessary to remedy the situation of Hajar and the others without delay and bring it into conformity with the relevant international norms, including those set out in the UDHR and the ICCPR. The working group considered that, taking into account all of the circumstances of the case, the appropriate remedy, as Lucy has already said before me, would be to release Ms. Hassan immediately and accord her and the others an enforceable right to compensation and other reparations in accordance with international law. The working group urged the government to ensure a full and independent investigation of the circumstances surrounding the arbitrary deprivation of liberty of Ms. Hassan and to take appropriate measures against those responsible for the violation of her rights. The working group requested that the government disseminate their opinion through all available means and as widely as possible. Now, as far as we know, none of these steps have been taken by the government of Bahrain since the WGAD opinion, which was adopted on the 19th of January 2019, so a good 9 months ago now. On the contrary, on the 25th of February 2019, the Court of Cassation upheld the sentences of all 3 individuals. This meant that they exhausted all legal remedies and are now serving the 3-year prison terms they were originally sentenced to back in October 2017. Furthermore, Hajar has been denied access to adequate medical care whilst detained in prison, in particular since August 2018, when she developed medical conditions that required specialised treatment. In fact, only 2 days ago, the UN Secretary General issued a report to the Council on the reprisals for those which engage with the UN, including Hajar. It states that the deterioration of detention and health conditions of Hajar has been reported. On the 16th of September 2018, Ms. Hassan was reportedly assaulted, harshly beaten, hospitalised, and then held incommunicado in Isa Town prison from the 16th to the 23rd of September 2018. The family of Ms. Hassan has reportedly not been able to see her since September 2018, and in January 2019 she went on a 2-day hunger strike to protest the restrictions after the publication of the working group opinion. The government of Bahrain, in its reply of the 19th of June 2019 regarding Hajar's case, indicates that no complaint has been lodged by Ms. Hassan through any of the national remedies, nor has she complained about not receiving medical treatment. Now, we know, and as Lucy mentioned before us, we know that simply is not the case. So in conclusion, I would urge the government of Bahrain to act in accordance with the opinion of the Working Group on Arbitrary Detention, and to finally afford Hajar, Sayyid Nasser and Mahmoud the justice that they are entitled to.
Thanks so much, Omar, for that detailed kind of drill down into that case in particular, which is really quite shocking. And I think for me, I mean, seeing as we're here, like the thing that really jumps out is that Bahrain is a member of the Human Rights Council. It sits there where the member sit in it has obligations to uphold as a member, and especially the reprisals aspect. I mean, that's not behavior which we should be expecting. And it would be interesting to see, I mean, the new reprisals resolution is being debated down the hall this afternoon. It would be interesting to see if in there anywhere is a mechanism for accountability for this sort of behavior. I mean, it's so vital that people continue to interact with the UN human rights bodies, and if they face reprisals for doing that, the whole system kind of breaks down. So thanks for going through that. That was super interesting. And now, Bridget, moving from that specific case to your wider findings, can you explain to us a little about the context of the report and its findings, and the similarities that you identified between the cases and how they relate to the wider context?
Sure.
Thanks.
I'm just going to shift these. Yes, thank you very much. So the case that Omar has highlighted here of Hajar Mansour Hassan is just one of the 9 women who feature in the report. However, her case does feature almost all of the human rights violations that all of the women have reported. As Lucy indicated, we traced their cases from the moment of arrest through their interrogation, trial, detention, and imprisonment to their release in some cases. Through reviewing the facts of their cases, we were able to identify similarities among their stories and practices employed by security forces and government officials. The violation of both Bahraini and international law began at the women's first interaction with Bahraini authorities, either through arrest or summonses to various police stations. Arrests were carried out without warrants and on occasion accompanied by excessive force, including officers in plain clothing and masks. 2 of the women, Fatin Nasser and Zakia Al-Barbouri, reported the use of paramilitary equipment and helicopters to arrest them from their family home. And Medina Ali reported that officers in plain clothing and masks kidnapped her from her vehicle on her way to work, beating her in their car on the way to the police station. The women who were summoned to police stations reported the use of a bait-and-switch technique, where officers would inform them that they were being questioned about a family member, then instead they were interrogated and charged with crimes. The interrogation process is where the women reported experiencing the most severe violence and psychological torture. All 9 of the women reported that the officers threatened to rape or kill themselves or their family if they did not provide confessions to the charges against them. 2 of the women, Zainab Marhoum and Amira Al-Kashami, reported that they were forced to listen to the torture of their family members. 3 of the women were subjected to an enforced disappearance after their arrest and during the interrogation period, with their families not being informed of their whereabouts, or with the authorities outright lying to their families about having the women in custody. 2 of the women, Ebtisam Al-Sai and Najah Yusuf, reported being sexually assaulted by officers of the National Security Agency. As a result of these coercive and abusive tactics, 5 of the women confessed to the charges against them and signed prepared statements. When Najah asked to read her confession, the officers beat her and threatened her with rape. During these interrogations, the women were questioned at length without legal counsel, despite some of the women explicitly requesting or demanding access to a lawyer. In a departure from the other cases, Zahra al-Sheikh was forced to film an apology to the King of Bahrain after officers from the Criminal Investigations Directorate threatened her and her family. Some of the strongest documentation that we had in preparing this report was used in the trials chapter, as we were able to obtain court judgments, public prosecution summonses and indictments, and other formal records of the Bahraini criminal justice systems. 8 of the 9 women were convicted. While Ebtisam was threatened with prosecution under terrorism charges, she was never formally charged. All 8 of the women who were convicted reported violations to their rights to fair trial and due process. To convict at least 6 of them, the court used confessions elicited by the women or their relatives under duress. In the cases of Hajar, Najah, Fatin, and Amira, the women's attempts to recant the forced confessions were ignored by the court and the public prosecution, with the court stating that the defense's arguments were just attempts to avoid punishment. At least 5 of the women reported restrictions or denial of access to legal representation before and during their trial, and 2 of the women, Medina and Zahra, were convicted in absentia, despite the fact that Medina was in Bahraini detention at the time. Amira, Fatin, and Zainab were also tried in mass trials, which impacted their ability to prepare a proper defense and violated their fair trial rights. 5 of the women were convicted under Bahrain's counter-terror law. Such legislation has been criticized internationally for its overly broad and vague language, which allows the Bahraini government to criminalize dissent, assembly, and expression as a threat to national security. In July 2018, under Bahrain's most recent review of its obligations under the ICCPR, the Human Rights Committee expressed concerns that the law, quote, includes an overly broad definition of terrorism that provides too much room for interpretation and may result in violations of the right to freedom of expression, association, and assembly, end quote. The committee also raised concerns about the, quote, extensive use of the counter-terror law against human rights defenders and political activists. During these unfair trials, the women were held in Isa Town for pretrial detention and later for their post-conviction imprisonment. As of October 2018, the total prison population in Isa Town was 205 inmates. Prison authorities allegedly subjected political prisoners to discrimination and punitive measures that are inconsistent with international standards. Hajar Mansour, Najah Youssef, and Medina Ali have all accused prison officials of acting in reprisals for international attention to their cases. Prison guards seemingly targeted them through physical and psychological abuse, including beatings, strip searches, and inappropriate touching, and intimidation. The three women also believe that the prison administration implemented a policy of collective punishment against the entire prison population to alienate them from the rest of the inmates. Measures included denial of or restrictions to access to medical treatment, participation in religious rites, family visitation, phone calls, and time outside of the cell. Prisoners also reported a lack of privacy and denial of drinking water and hygiene products. In addition, Ebtisam also described inadequate standards of hygiene, which resulted in one known instance of food poisoning for herself, Najah, and Zainab. In protest of poor prison conditions, Amira, Hajar, Najah, and Medina each resorted to hunger strikes at different times during their detention. 6 of the women submitted complaints to Bahraini oversight bodies, as Lucy mentioned, including the MOI Ombudsman, the National Security Agency Ombudsman, and the Office of Public Prosecutions Special Investigations Unit. These oversight bodies have failed to fulfill their mandate in each case, with the majority of the responses dismissing the issue at hand and finding little or no fault in the actions of state officials. The institutions have failed to investigate complaints adequately, delayed investigations unnecessarily and unreasonably, and in some cases, neglected to respond. On 2 occasions, the MOI Ombudsman even violated their confidentiality policy. It is clear from our interviews with these women and the report that the ill treatment, torture, coercive interrogation tactics, unfair trial, substandard conditions of detention, and whitewashing of oversight bodies are not merely coincidental, but are part of a systematic repression of the Bahraini population. I would like to note the relevance of the timing of this event. September is the first anniversary of events that have impacted multiple women in the report. 1 year ago today, the video of Zahra al-Sheikh apologizing to the king was posted on her Instagram account without her consent. I first saw this video shared on social media while here in Geneva for the council session. Months later, we would begin to document her case and learn of the ill treatment and psychological pressure exerted by the authorities to force her to record this video. Last September also marked, as Omar had mentioned, when Hajar Mansour, Najah Youssef, and Medina Ali were assaulted by prison guards, reportedly led by Lieutenant Colonel Mariam al-Bardoli in the prison. This is also a particularly vulnerable time for the prison population in Bahrain in general, as we are in the month of Muharram, a holy month observed by Shia and marked with commemorations, processions, and sermons, which have been attacked by security forces. In the prisons, including in Isa Town, prison guards restrict access to religious texts, prevent prisoners from participating in communal prayers marking Ashura, and guards mock Shia beliefs and practices. Finally, I would like to note the significance of the title that we have chosen for the report, Breaking the Silence. As Lucy noted, the report was based heavily upon interviews and written testimony provided by these women, and appropriately, the report features multiple quotes from each of these women. We have viewed our role as amplifying their voices rather than speaking for them. So I would encourage everyone to read the report and pay particular attention to the words of these women. Thank you.
Thanks so much, Bridget. And the amplification aspect you were talking about really comes through in the report. I thought it was really powerful. And considering how little access you had, that's a great job. Well done. But thank you so much as well for going down into the kind of similarities between the cases. I mean, we can see so clearly that they follow a pattern, and that it's hard to see, despite the recommendations that you have, kind of how to break this pattern. I mean, I suppose breaking the silence is the first step, but the next thing we want to do is break the pattern. So it'll be interesting to discuss how we think that could happen later. But first, we turn to Oliver. And obviously, this is all taking place in a framework of the wider international human rights law and violating such human rights law, as Bridget and Lucy and Omar have all pointed out. So could you possibly offer a legal analysis of the torture and fair rights trials issues that apply to these cases in the report?
Yeah, of course.
Thanks so much.
Well, thank you very much, everybody. Good morning. You've heard a lot of words being said, so I'm going to try and keep this brief so that we can have some questions and answers. May I first thank Adhrbو Bird and the other organisations involved in the drafting of this report for inviting me to participate, albeit in a minimal capacity compared to the immense efforts of other members of this panel and the rest of the teams here in Geneva and elsewhere. Just to be clear, I acted in an independent role, working and analysing the reports that were provided to me, or the information. First, I wanted to impress the fact that my legal analysis is not based on an assessment of general notions or concepts of international human rights law or international ideals. It is based on Bahrain's obligations under international human rights law. It's been mentioned briefly, but I think it's worth reiterating that Bahrain has ratified or signed the International Convention on Civil and Political Rights in 2006, the International Covenant on Economic, Social and Cultural Rights in 2007, the Convention on the Elimination of All Forms of Discrimination Against Women in 2002, the Convention on the Rights of the Child in 1992, and the Convention Against Torture in 1998. Importantly, Bahrain's obligations do not start and finish at the point of ratification. We've done that. What's next? But it creates an ongoing obligation under international law to continue to uphold and protect the rights found in these instruments. These obligations continue to this day and into the future, so long as Bahrain is a party to these instruments. The report shines a light on what is, in my opinion, based on the information provided to me, failures to uphold and protect the rights that Bahrain is obligated to under these instruments. So, briefly, what does the report contain and what are my conclusions? I want to highlight 4 particular areas, although these are detailed in much greater length in the actual report itself. The first is the inhuman, degrading treatment, and in some cases, in my opinion, that may well amount to torture, that these women have been subjected to. The use of intimidation by authorities used in conjunction with forcing detainees to be held in cold rooms, sleep deprivation, may well amount to inhuman and degrading treatment and, as I mentioned, potentially torture. Failure to properly examine and investigate allegations also violates international law. The second point to raise is apparent violations of fair trial rights, which we've mentioned before. 5 issues come to mind immediately from the report. First is a lack of representation, which we've discussed. Secondly is the use of confessions allegedly coerced at the time of interrogation. Third, the failure to a proper defence. Fourth, the seizure of documentation that may well assist in those defences. And fifth, the apparent use of mass trials. There is a worrying pattern emerging from all of these, that in key moments in interrogation and at court, there have been clear contraventions of fair trial rights. The third point to highlight, and again this has been mentioned, is the abuse of counter-terrorism legislation. The use of legislation that, at least on its face, was passed for good reason, but is now being used to target individuals, human rights defenders, activists, lawyers, and researchers. This is unfortunately not an issue we find exclusively in Bahrain, but in the region and across the world. And its use, the use of anti-terrorism legislation in this way, amounts to a violation of international law. Finally, I suppose underpinning all of these concerns is violation of the freedom of expression, association and assembly. It's worth mentioning, and I don't think it can be mentioned enough, that freedom of expression and associated rights is not just about making laudatory comments that are supportive of government and rulers. But the freedom of expression is also a freedom to make remarks and comments that challenge and disagree with those in positions of power. The call for upholding of the rights we've discussed that Bahrain has ratified in these instruments should never be the basis for the detention, prosecution and sentencing of individuals. So, what can be done? Many of these recommendations are already in the report, but I just wanted to highlight some of them. Whilst Bahrain has signed or ratified several international human rights instruments, it has not signed the protocols that allow individuals to petition various UN human rights bodies, such as the Human Rights Committee and the Committee Against Torture, and allow for visits. Bahrain should immediately sign these protocols. For those individuals cited in this report, Bahrain should create an independent and transparent inquiry compliant with international standards to fully and impartially investigate the allegations. As I say, any such inquiry must be fully transparent and make its findings public. Where investigations lead to credible evidence, prosecutions should commence against those responsible for torture and other related crimes, whether they're alleged to have committed, supported, or assisted in the treatment described in the report. Where investigations lead to credible evidence that the judiciary have failed to follow international standards for the consideration of torture-tainted evidence, in addition to criminal responsibility through prosecutions, disciplinary actions should be taken, leading to the root and branch removal of judges and authorities who continue to allow the use of torture-based evidence in court. Civil society must continue to knock on doors in this building and elsewhere. Reports must be written, and continued engagement with special rapporteurs, working group on arbitrary detention and other bodies must continue. Other member states have a role to play. They must read this report and use diplomatic relations to assist and support Bahrain in complying with its international obligations. And where it fails to do so, be prepared to highlight and question these failures in the strongest terms. Bahrain must ensure the safety of human rights defenders, activists, lawyers, researchers and others who work in the sphere of human rights protection and promotion. Finally, may I ask you all, when you receive copies of this report, to turn to pages 19 to 21, as I think will be in the final report. These are the biographies of the women whose brave actions underpin this report. The report is not based on abstract statistics or numbers on a page. It may well serve some for it to be thought of that way, that these are numbers and statistics without a connection, without a human connection. But this report is based on the actions of women who've risked everything to support and promote human rights in Bahrain. It is now for Bahrain to uphold its international obligations. Thank you.
Thanks so much, Oliver. Thank you for highlighting the ways in which Bahrain is falling far short on its international obligations, for any state at all, and much less for a member of the Council. And thank you as well for highlighting the fact that these are real stories behind the numbers. I think that's something that gets lost in here a little bit, that everything that's said in the Council chambers is backed up by someone who've had their rights violated, often in a very terrible way. Thanks, sorry. And I'm just going to open the floor for questions. I have about 1,000, but just in case anyone else does first. Tyler, please.
Yeah, my name is Tyler with KDHRB. So I noticed that the ASG's term is up at the end of this session, and there's a very prominent case of reprisals that we've touched on here. I believe Hajra's case appears in his most recent report and also in past reports. And I'm wondering, maybe suggestions about what future candidates for the ASG, can do about very obvious cases of reprisals in ways maybe that they could work with the Council and the other UN systems to ensure that there is accountability across the UN system and not just reports sent off into the void. This is for all of you. Thank you.
Cool. Thanks so much. Anyone else before we tackle that one? No. Okay. So I turn it back over to the panelists. As Tyler said, there's a new ASG going to start whose focus will be on reprisals. As this is such a prominent part of this report, how do you see the accountability coming in? What can be done to make that system stronger in order to achieve real accountability and real justice?
I think the system as it exists, definitely we need to make it cut teeth a bit stronger. Right. Obviously, just the example that I was talking about, yes, you can have a working group decision that comes out that clearly identifies that, this example, as many others, as an example of reprisal. However, I would argue that's not enough. We do need to have I'm going to fudge this because I don't have the answer. But then, I think you're completely right. It's not enough for a decision to come out if it doesn't actually carry any weight. We need to be, for our advocacy purposes, it's important to be armed with a decision from a UN working group body, which can then substantiate the claims that we're making. It's not just noisy NGO workers, but instead we have the UN authorizing that this is, like we said, these are real people, these are real people's stories, and they have been substantiated that there is reprisals taking place, there are violations taking place. And then we can be armed with that decision to go on and leverage, whether it be governments or other UN bodies or other sources. However, I think you're right. I think especially with the opportunity now where reprisals is being considered as a particular topic, I think it's time to explore how we can take that one step further. If anyone else has any suggestions, but yeah, I agree that there is an issue and there is a need to develop a more enforceability aspect to this, an enforceability dimension. So I guess we're going to have to put our heads together.
I'll add something too. I do know that OHCHR reprisals do seem to be something that they are following up on, that they're interested in. It's brought up consistently at every council session that reprisals are a problem. However, most of the time when it is mentioned at these council sessions, there's never an element of naming the perpetrators of those reprisals. It's not a name and shame kind of game, and we've seen this from various council presidents. So we kind of want to see, whenever a new president comes through, what that presidency is going to look like. Will they, so to speak, call out any states if they're engaging in reprisals during the council or before council? We do have several Bahraini people mentioned in the ASG's new, or the SG's new report on reprisals. Hajra among them, as well as Nabil, and Abtisam's case as well is also included. And there's just the notion of sweeping travel bans that have no longer started to be imposed. It used to be that travel bans were issued specifically around Geneva and specifically around the Human Rights Council session, and instead we've seen the tactics change. So there's not even a paper trail anymore. There's no longer a travel ban stating that this individual may not travel. Now it's just coercive and intimidating tactics being carried out, threatening to kill and rape family members of individuals who they know have previously attended council sessions or are active in the human rights community on the ground. So that has of course led to the fact that there are almost no Bahrainis. There are no Bahrainis who come from Bahrain in the council. They're always expats or people who have fled the situations, unfortunately. So yeah, reprisals are something that we follow closely, and that it'll be interesting to see what happens going forward, because this is somewhat of a newer mandate. So it's still sort of being developed, and I do know that special procedures are starting to pay attention to the issue of reprisals as well. But I think the onus is on us as well as NGOs who engage with those bodies to follow up and to make sure that they are aware of these issues, and if it's in particular based on special procedures or anything like that.
I would add to that, in terms of the work that NGOs like ourselves and others do, it really is essential, because if, as Lisa mentioned before, if there is this real risk of reprisal, then that is going to put off other individuals. You know, it's already a hugely intimidating process to come forward and share information with lawyers and with investigators, with NGOs anyway, and they're putting themselves at huge risk. Now, if there's going to be this additional risk that engaging with these UN bodies is going to increase the risk of reprisals, that's really going to deter people from engaging with the system. And, you know, any risk of people not engaging is going to only make the work that we all do much more difficult, and furthering the cause much more difficult. So it's a really important thing that needs to be addressed.
And may I add to that, so as NGOs and international human rights community, I think we need to be ready to react and to act on behalf of these women after these decisions come out, in case they are subjected to further reprisals, as it happened in the past. As it was mentioned during this event last year, after the Secretary General published its report on reprisals, these women were subjected to assault. Every time their cases are raised at the Parliament level or like international level, there is an immediate reaction, especially in those like high-level, high-profile cases. When the Working Group on Arbitrary Detention published its decision in January, the Bahraini government started a defamatory campaign against Hajar's son-in-law and Bird's director to sort of try to like defame its authority and Bird's authority, going even against the findings of the UN. And I think it's quite problematic when Western allied governments don't support the findings of the international human rights community, and rather than supporting those findings, they sort of like follow the line of the Bahraini government, which actually is quite detrimental or dangerous, because it sort of gave them the green light to continue these reprisals and these abuses without fear of any consequences.
Yeah.
It's just to say, it's a difficult judgment call as well, because obviously on the one hand we would never want to put individuals at greater risk. Exactly. However, we also can't fall into the trap of not raising these cases and raising the profile of these cases for fear of further reprisal, because then that's not holding the governments that are responsible accountable to their actions. So, you know, whilst we take every protective measure we can, it's still important that these cases are raised at every available opportunity, should they consent to it.
Yeah, you're right. And some kind of accountability mechanism, some kind of political cost. At the moment, you can carry out reprisals almost as much as you want, and you might be mentioned in the report, and then every year there's an interactive dialogue. But apart from that, there's no political cost whatsoever. And I think raising that would be something that we should really think hard about how we're going to achieve in the next, well, as soon as possible, really. But Oliver, as our resident international law specialist.
No, I mean, this is something that, you know, this is not a Bahrain exclusive issue. I mean, I would just say, I mean, all these comments I can only echo. I would also just add that I think there is strength in numbers in terms of trying to demonstrate patterns in reprisals as well. I think when we have individual cases, there's always an opportunity for it to be explained with a sort of different explanation. Oh, that happened because. But I think one thing that is potentially worth focusing on is trying to collate information that demonstrates to working groups or whatever, these aren't individual cases, but these are actually patterns that are, and where you see patterns, then I think there's more strength in advocating that these are actually, these must be reprisals, not allowing member states, be it Bahrain or other countries, just to say, oh, that's a one-off occasion, like that had nothing to do with it. Where you start having dozens, maybe, of cases with those similarities, you can then potentially strengthen the case.
Yeah.
And on Tyler's point of engaging different UN bodies, I think that's the beauty of, if you the working group, the beauty of a working group is it's specifically on one case. However, if you were to do something like a general allegation letter, you can draw those patterns together, thematic issues off reprisals. So as in, if you run them both in tandem, then you can kind of attack using different UN mechanisms at the same time.
Yeah, I think Bridget always says that some of the special rapporteurs are already looking at this, but persuading them to look at these as in the round rather than in individual complaints, I think has a potential to be more impactful. As you say, as Omar says, running alongside individual complaints, but this sort of force of weight of saying there are so many cases, this isn't just a one-off type situation.
Yeah, agree. And on that note, as you offer kind of recommendations for going forward, I think we're being kicked out of the room, so we're going to have to close. But thank you again so much to our panelists, and thank you for coming. It was a great discussion.